Oh yay, oh yay, oh yay. The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
We got everyone? Welcome, gentlemen. How are you today?
Fine, Your Honor. How are you all?
We are doing fine. As you know, I'm Justice Alvarez, and I have Justice Luz Helena Chapa with us, and we also have Justice Lori Valenzuela. Do you have any announcements before we get started?
No, Your Honor.
Okay.
Thank you.
So today we will hear the arguments in cause number 04-20-125 CV, Pay and Save versus Roel Canales. You'll see the timer here, gentlemen, in the Zoom window. Can you see it?
Yes, Your Honor.
Please stay within your allotted time, and if the light turns red and your term has expired, if you need additional time, just ask us for it, and I will make sure that the other side gets equal time. I don't think you'll need it, but in any event, if you do, please let us know.
Your Honor, if I may, I don't see the timer on my screen. So
okay, that's why we're doing this. Okay. I need Mr. Dell.
See, the mute.
You may want to change to gallery view, Charlie, if you're not already on it.
Yes, Mr. Frazier, just go ahead and switch to gallery view.
There we are. Yes, I had the gallery earlier now. There we go. Thank you, Bill. We're in good shape.
Okay, great. Okay. There being no announcements, let's get started. And when you're ready, Mr. Frazier, just let us know.
Very good. Well, good morning, Your Honors, and may it please the court.
It does.
It's very good to be before the court again, and I look forward to presenting argument, and thank you for having this oral argument for both parties today in your busy schedule. So, may it please the court, the judgment of the trial court should be reversed because the watermelon display at the Pay and Save store did not constitute an unreasonably dangerous condition for the following reasons. First, whether a condition is unreasonably dangerous turns on the probability of injury, as this court held in Dietz and as the Texas Supreme Court held in the Suthernet case. Although there is no absolute requirement of prior incidents, Texas courts have consistently held there is no evidence of an unreasonably dangerous condition because there's no probability of injury where the condition existed on the premises for any length of time, especially for multiple years, and there was no prior incidents arising from that condition. Here, Your Honors, the evidence was undisputed that Pay and Save used open-sided pallets for 14 years at this store, and there were no prior incidents where anyone's foot became stuck in the pallet opening, much less sustaining injury thereby.
May I interrupt you, Mr. Frazier? May I interrupt you? And by the way, we're going to put our hand up whenever we have a question, and that way, if you notice, the justices with their hand up, please let us ask our question. I do have a question right here, and this is with regard to a premises liability case. We have two experts, and of course, assume with me that you're correct that their testimony is speculative, but do we really need an expert in this case to tell us that this pallet is dangerous? Should we have enough with the photograph that is in evidence? What are your thoughts on that?
Your Honor, I do agree. I do not think under these circumstances, and Exhibit 3 of our argument exhibit show again the pallet and see how open it is around it, that this is not a situation where the experts really aid the jury. I think jurors can determine this because it is a common occurrence, as our brief sets out and as the record, more importantly, sets out. So I don't think expert evidence is really helpful in this case because of the common nature of the condition, that it had been there for so long, and that the layperson can know whether this, in this photograph, in this circumstance, whether that is dangerous. That's in their common knowledge. But as Your Honor pointed out, they do have experts. Don't think, no, their testimony is not probative for several reasons, but I don't think in any event that it was helpful to this jury or was necessary.
Okay, well, we can discard the expert. So let's go and see, is this pallet, dangerous just by looking at it? What are your thoughts about that? And we're going to the first element of a premises case.
Yes. Well, to answer your question, I will quote this court's definition of an unreasonably dangerous condition, which is, of course, consistent with the side in that case, which the court was citing. And that is when there is a sufficient probability of a harmful event occurring that a reasonably prudent person would have foreseen it or some similar event as likely to happen. Got two probabilities in there. Mm-hmm. A sufficient probability of a harmful event occurring that a reasonably prudent person, here pay and save, would have foreseen it or some other event as likely to happen. And when looking at Exhibit 3 and the photograph, and we included this photograph, Your Honors, it's tab 3 or Exhibit 3, because this is exactly where, under the record, Mr. Canales fell. He came in through the doors you see in the background. He came around be going from our right to our left, came around the display, and right, I guess to the left of the corner, he picked out these round watermelons, and near the corner, I suppose he was there, his right boot got caught, and then, because he said, when I picked it up, then I turned to the right, and you have to go to your right and go around where the word admitted is. You go around because on the other side of the Sprite and Coke displays is the checkout right in front of the front doors. So see how open it is around that display. It was not tucked in where you had to squeeze in and inch your way in between some display or something to get. He was on the most open side of this display. Look how many, it's hard to tell, but those pallets are 4x4 roughly. Yeah. And so you can see that it's 4 feet at least away from the edge. So I believe, Your Honor, that based upon this photograph alone, along with that it's so common, it's every day. Mr. Canales had been in the store hundreds of times, he said. He has bought watermelon here before without incident, as well as untold number of customers for 14 years, that this is simply not an unreasonably dangerous condition, because you don't have the sufficient probability of a harmful event such that Fancy would have foreseen that event or something similar as likely to happen.
Well, let me ask you this. Isn't that for the jury to decide, though, if it's unreasonable? Shouldn't we leave it to the jury to decide? And they decided that it was unreasonable, regardless of Mr. Canales being there hundreds of times, like he said.
Well, yeah, I mean, yes, premises cases are submitted to the jury, every day. It is a fact question, and that's why we argue that there is no legally sufficient evidence to support the jury's finding. Uh-huh. And so there are multiple cases, Your Honor, we have cited them, multiple cases where even under the no evidence or factual insufficiency of the evidence standards of review, notwithstanding those standards, and the court obviously well knows that. Yeah,
but you also have... You infer... No, I'm sorry. I interrupted. I'm sorry.
Well, under that standard, the court knows that you defer to the jury. All inferences to support the verdict, all of those. But there are loads of myriad cases where even under that standard, the court said there was no evidence. The jury got it wrong. The court got it wrong. So yeah,
there's also case law that says it takes one case, one case to determine. In other words, you don't need that history of cases. But that's for notice and that's for knowledge. So I want to focus on dangerous. Assume with me that the first element is met. It's a dangerous condition. Okay, just because it has all those holes and you can trip and fall, or your foot can get stuck in one of those holes. Tell me about the University of Texas versus Pan Am case, the Supreme Court case. Would you agree with me that that case, bottom line, stands for, the proposition that generally you consider whether other reports are prior injuries, but not necessarily so?
Right, yes. And that's the case where I assume it was the student, tripped over the hose that had been laid out on the lawn of the university, like most colleges and universities have those lawns. And but your honor is right. As I said in my opening, there is no requirement, there is no mandate or absolute requirement of prior incidents. But I will say, your honor, in that case, the Pan Am University case, as well as this court's opinion in Dietz, and then we'll get to the side neck chart, that's where the courts really first go. And that's where they all do that. And there are several cases that we cite where the court compared the facts to actually one of this court's cases and say, well, there was no prior incidents, but here there were, and it was a similar water coming into the door of the store. So even though it's not an absolute requirement, your honor, when you have our facts with this length of time, with no complaints and no injuries, and we understand it doesn't have to happen exactly as Mr. Canales' injury did. We get that. But it's very important to know that the reason that Appellee says this display, your chart 3, exhibit 3, is dangerous is because the pallet was open. That's what he is saying makes it dangerous. It's not like this pallet was defective, or there was a splinter hanging down, or that it was extra large, or something, that it was defective or unusual. No, there's no allegation that this was any different than any other pallet in any other store in South Texas.
And I think we understand that, but I go back to the jury. Is it a jury question? The jury had the evidence, they had the pallet, and it was submitted to the jury. And what you're saying, it's not legally sufficient based on the cases that you cited. And I'm saying the cases that you cited are distinguishable. And I guess you agreed on some of them, correct? Which ones don't you agree on?
What do you? In what way? I'm sorry. What way are they distinguishable, Your Honor? What's the distinguishable factor? And I'll try to address that.
Yeah, and thanks for asking that. You're saying that, for example, Aguilar. Aguilar considers the prior injuries as evidence. Okay, but you're saying as to the dangerous condition, we have the Dietz case. And we also have the Aguilar case was the house case. So you're saying that those are not distinguishable cases, correct? And those, we should follow those for the legal aspect of the premises case, correct?
Well, we're arguing, Your Honor, that this court follow its jurisprudence on what a dangerous condition is, and that the cases that I'm not sure what's distinguishable. I mean, there are some cases.
It is a dangerous condition if you look at those holes. Anybody can go in and step in, and what I'm seeing is that you're saying, well, he was there before and he should have seen it, and that's kind of, to me, an assumption of the risk, and we don't have that. So tell me why I'm wrong.
Okay, no, thank you, Your Honor. I love these questions, and I will do my best to answer it. Now, taking their evidence, they say it's dangerous because someone's foot could slip inside it, that it's big enough for the average shoe, or in this case, a work boot, to go in at least partially. And because it can go in, then they jump to, well, then that makes it unreasonably dangerous. And that's not the test that this court set out. Just because a foot could go inside a pallet does not mean that the probability of injury will be existing, that it is likely that there's sufficient evidence or probability of injury from an opening. They didn't say anything about anything else. The fact that it is open and someone's foot could go into it, ergo it's unreasonably dangerous, defies this court's definition of what unreasonably dangerous condition is, period. Just because someone's foot can get in, is it foreseeable that you would have? Well, that's why the foreseeability or the nature of whether something is unreasonably dangerous turns on probability. Your Honor, they go hand in glove. You can't have
Mr.
one without
Frazier,
the other.
Mr. Frazier, if I may interrupt you there. Okay, reasonably speaking, due to the fact that the opening is open and obvious, and we can all see that, let's safely assume that the jury was able to see that. Is it reasonably foreseeable that, for instance, if there was one more watermelon in the cardboard box and someone is much shorter and needs to insert their foot for leverage and balance to reach the watermelon? I mean, isn't that reasonably foreseeable for someone in South Texas? My stature, for instance, I would need that. I would need to put my feet in there for balance to reach that last watermelon. Isn't that reasonably foreseeable?
Well, ergonomically, I don't know. I suppose it thought it'd be better to put the foot on the corner where the arrow is and balance yourself and lift yourself up on that. We have another side or two sides that don't have the openings. So again, it turns on that for 14 years with thousands of customers, it just is just not foreseeable. To look at from pay and save standpoint. Now remember, you look from pay and save standpoint prospectively, based upon the history that we know in the evidence, Your Honor. It's a great question, but based upon all that, you don't take it in a vacuum. That if it's likely that someone will put their foot in, you have to go a step further and say, is there substantial, evidence or is a substantial likelihood of there being a serious injury? The probability of a harmful event occurring.
Mr. Frazier, is substantial your word, or is that based on some authority?
Well, it's substantial. I should say the probability of a harmful event is likely, such as that event is likely to happen. So it has to be of sufficient probability of a harmful event. And this watermelon display, which if this is reasonably dangerous, Your Honors, then thousands of displays across various stores of various grocery stores, from Walmart to H-E-B to Winn-Dixie, are going to be unreasonably dangerous. And I think that it's not because probability is part of it. The fact that someone who may be short may have to get a little bit closer to lean down, then maybe that's probable. There are two bins, but there are a lot of people of short stature that have been in that store for 14 years. And so I don't think, Your Honor, that renders this display, tab 3, unreasonably dangerous under the facts and under just the common knowledge and on where it is. It just doesn't. There's no case for this condition existing for any length of time like this, with no prior incidents where a premises owner has been held liable. Plaintiffs Mr. Canales hadn't cited one. We haven't seen it. I think this will be the first.
Mr. Frazier, I believe there was some discussion about some guards that you can place over the open areas. Is that correct?
There's some evidence that there are plastic pallet guards that are out in the industry. And plaintiff tried to, argued that the existence of the patent set the industry standard. But of course, it does not. The case they cite does not hold that. It's out there, but it's well known that just because there is a remedy, an alternative that is easy or safer, feasible alternative design without more is no evidence that the owner knew or should have known that it was under a dangerous condition. That's the CMH Holmes case. So the existence of a patent on the plastic guards, the fact that some stores use them and some don't. But what's really key about their evidence is that the industry standard, at least in South Texas and beyond, is not to use the pallet guards. The industry standard is to use the open pallets. Their own experts said years and years, that's the way it's been done. That's the way it is now. Some do and some don't. That's the undisputed evidence. So the existence of the pallet guards in the industry is no evidence that this display is unreasonably dangerous, because the mere knowledge of a alternative feasible way of explaining, of presenting it is no evidence that this is unreasonably dangerous. And that's why.
And that would go more to perhaps a design case or not necessarily a premises case. So should we, you're essentially saying that it's no evidence with respect to the premises liability case.
Right, there's no evidence. And that rule, Your Honor, about if the premises owner knew of a safer, feasible alternative design without more is no evidence, that is a premises liability case. That is a premises case. And so the existence of the plastic pallets is no evidence that renders this display unreasonably dangerous. The existence just doesn't. And that's why, go ahead. I mean, that's why their opinions, if we want to even use them, are based upon facts and assumptions that are contrary to the record. I see my time is up.
You need more time, Mr. Frazier. You still have the damages issue. Would you like more time?
Well,
we took a lot of your time, so
yeah, that's okay. Well, if I may briefly say, getting to the actual constructive knowledge.
Wait. Do you need more time?
Yes.
How much more time do you want?
Just 3 more minutes.
Okay, we'll give you 5 minutes.
Okay.
And we'll give Mr. Cross 5 minutes as well.
Okay. Well, the actual constructive knowledge is basically that, the arguments that just because there were no complaints or injuries reports does not mean that they did not occur. They make that argument that, well, yes, they don't have any prior knowledge, and so they couldn't foresee. They didn't have the actual knowledge, and we didn't. There was no evidence of the actual knowledge. But they say, well, not all reports may have been reported, or incidents may be reported. Well, there is no case, Your Honors, where a court has lessened the probative value of no evidence of prior incidents based on the idea that, well, not all falls and incidents are reported at a store. Do we think that all incidents at Kroger, H-E-B, Walmart, or other store are reported? That is just a red herring, and that does not.
Yeah, but Mr. Frazier, let me interrupt you, Mr. Frazier. Isn't it common sense? I mean, I looked at that picture. The first time that I looked at that picture, I said, oh my gosh, no, they have a problem, okay? The jury could say that as well. Isn't that for the jury to decide? Well, you have the evidence there. Isn't that for the jury to decide whether they, because I mean, it's very obvious what you're talking about is something that's hidden, and this is very obvious.
Well, Your Honor, that's exactly the point.
Okay.
This is open. This is obvious. Everyone knows. Everyone has seen these displayed for years. They bought watermelon without incident, and that's very important. If you would go to Exhibit 1 of our bench exhibit, Your Honor, I'll go briefly. This is the Texas Supreme Court case, Sideneck versus Cal Barenther Associates, 1970. Plaintiff cited several times in her brief. If you compare the facts of Sideneck to this case, as we did in our brief, Your Honor, with Dietz and this case, you can see it follows a line. It follows right along. The defendant's showroom, the portion walked up to a display, a table, to look at the tag, and in doing so, got the heel caught in a rug that came out just enough, but there's nothing to give her any idea of drawing her attention to it. And her heel, I guess it was a narrow heel, got caught in the loop of the rug, and she fell backward and she fractured her wrist. Very similar circumstance. It was, a smooth floor, a rug, looking at the table. She was focused on the price tag. Mr. Canales was focused on that watermelon. He said he didn't see the open side, even though it had been there for 14 years and he'd been there 100 times. She said she didn't notice the rug. It came out just a couple of steps. She stepped into it and she said her shoe got caught. Her heel got caught. His foot got caught. Look at the fourth chart there, the line. There was nothing to call the attention. Same here. There was no evidence that anyone had previously tripped on the rug or that the rug was defective in any manner. Those are our facts. That's our case. And so the holding was the evidence that the rug and its placement created an unreasonably dangerous condition. They said that there was some evidence. So there was a fact issue, but it was so weak, Your Honors, that it amounted to mere surmise or suspicion of its existence and was in legal effect no evidence and will not support a verdict or judgment. So the fact, Your Honor, that it went to the jury, that is normally a fact issue. Jury verdicts get reversed all the time because they're not based on legally sufficient evidence or alternative facts of sufficient evidence. So that's the case here. Even though it's for the jury to decide, we're saying that there's no evidence to support the decision that they did make. And before my time runs out, I would just want to briefly say, if the court has any questions regarding gross negligence, I think this is clearly not a gross negligence case. The standard that is so heightened, and there's just no evidence that this pallet posed an extreme risk of injury. An extreme risk is not a remote possibility of an injury or even a high probability of minor harm, but rather the likelihood of serious injury to the plaintiff, and that the defendant here, Pay and Save, knew about the peril and just simply decided to do nothing about it. There is no evidence to support the jury's finding of gross negligence. Yes, they were asked, was this an extreme risk of harm? Did this present an extreme risk of serious injury, of likelihood of serious injury? They answered yes. Likewise, Your Honor, we believe in the jury system. It's the best system in the world, but sometimes the evidence does not support what the jury finds. And it was submitted, but not on the evidence. The evidence doesn't support the gross negligence, and Your Honors, it doesn't support the finding of premises liability, because this is not unreasonably dangerous. It's everywhere across Texas. Thank you, Your Honors.
Thank you very much, Mr. Frazier. Mr. Cross? We can't hear you, Mr. Cross.
Actually, that would,
all of us, by the way.
Actually, that would be Mr. Chris, Your Honor.
Oh, I'm sorry. I'm sorry. I apologize.
All right. May it please the court. I'd like to make 3 observations, and then I want to go directly to what makes this case distinguishable from the ones that have been cited by the appellant. The first thing I just want to point out is that there is no error that has been brought forward by the appellant in this case with respect to any ruling that Judge Baligarza made in the trial of this case. This is not a case where the trial judge made any mistake. The only thing we're dealing with here are basic, vanilla, everyday, ordinary, we didn't like the jury verdict, so we're going to claim it wasn't supported by sufficient or legally sufficient evidence. Second, as the court's already pointed out, the nature of the appellant's argument is basically confined to misapplying or misconstruing the standard of review in this case. You can't just throw out all the evidence that was put before the jury in this case for a week trying this case, including evidence that the defendant itself either introduced into evidence in the form of exhibits or else the testimony of their own corporate representative. And lastly, one thing that I really would like for Pay and Save to address in their rebuttal time is, where is this South Texas? Why do they keep talking about South Texas? Is South Texas, does San Antonio, is that part of South Texas? I've been part of South Texas my entire life. Are they claiming that South Texas is everything south of I-10? Are they claiming that South Texas is just Duval County? What about Jim Wells County? What about Hidalgo County? We don't know. But the one thing that we do know is that the appellant throughout the trial and appeal of this case was very careful to try to confine every court and jury's inquiry in this case to some microscopic or very small focused area, geographic area, that they amorphously describe but never define as South Texas. So what we don't know is what people do with respect to watermelon displays in Dallas or in Fort Worth or in Lubbock or in West Texas, where this company is headquartered. We don't know what people do with respect to displaying watermelons in any of their other 149 stores. For some reason, there's nothing in the record except for the testimony that we introduced about what the sophisticated cities of the plain do with respect to the display of watermelons and other produce. The evidence in this case is that up until 2000, nobody used pallets to display produce. It wasn't until Walmart and Costco got into the volume business of displaying these things that they started just dropping the pallets on the floor. At some point, after they started doing that, they started reconfiguring the displays to put warning arrows on the corners and to cover the corners of the pallets that stick out beyond the octagonal cardboard box in which the watermelons are displayed. And that right there is all the evidence that the jury needed that the trip hazard that we alleged in this case and that injured my Vietnam veteran 74-year-old client 5 years ago was unreasonably dangerous. They knew it was unreasonably dangerous, which is why there are warning arrows on the box.
Justice Valenzuela, you go first.
Okay, so you're telling us that the arrows on the corner of the boxes, which I believe the record suggests are to point to the corners of the pallet, is constructive knowledge of the hole that is underneath the pallet. Is that what you're saying, Mr. Chris?
Absolutely, Your Honor. And the reason is this. The evidence in the case is that the reason that those cardboard triangles cover the corners of the pallet is because they don't want people stepping on the pallet. And those corners cover interstices or gaps between the slats that are on the top of the pallet to prevent people's feet from going in there. So they know there's a trip hazard. Their own corporate representative admitted there's a trip hazard with respect to people encountering those pallets. They protected against people stepping into the pallet from the top down because they knew it was dangerous. They just didn't protect against people stepping into the pallet sideways. So how can they? That's why they keep talking about South Texas. It's like a truck driver who says, I know it's unreasonably dangerous for me to talk on a cell phone in my right hand because I was in an accident doing that. But in this accident that you're suing me over, I had the cell phone in my left hand. How did I know that was supposed to be unreasonably dangerous? That's their argument in this case. And the way they do it is by artificially trying to limit the focus of the duty inquiry. And you're just not allowed to do that. You're not allowed to say, well, in South Texas, we don't have to protect against this. We don't care that you have experts that say that there were devices to protect against this very danger that were in the stream of commerce 10 years before this accident. We don't care that our own corporate representative testified that he was present at the national meetings and on the board of trustees of the National Grocers Association, at which these very devices were marketed. We don't care that the patents that were introduced into evidence to support these devices demonstrate and state that the reason they should be placed in the stream of commerce and approved by the U.S. Patent Office is to protect against the danger of people falling in precisely this way. Yes, Your Honor.
I got a question, Mr. Chris. In South Texas, how do we deal with open and notorious?
Open and notorious?
Yes.
Well, Your Honor, one of the ways that the jury dealt with an argument that, Mr. Canales should have known where he was going is the jury found contributory negligence. And the jury found that Mr. Canales was 30% responsible for this. This is not a runaway jury case. This is not a case where the jury just decided to throw up its hands and start throwing grenades at a defendant. This is a case where the jury thought very carefully about the evidence in the case, including the industry standard nationwide. And the jury considered the argument of pay and save that, hey, Mr. Canales, he'd been in that store 100 times. He should have known better. That's called contributory negligence. And you know what? When Sedenek, their White Horse case was decided in 1970 by the Supreme Court, Mr. Canales would have received nothing in this case because Sedenek was decided before Article 2212A was adopted, which is now Chapter 33 of the Civil Practice and Remedies Code, and which now provides for modified comparative causation, comparative negligence. If the jury had found Mr. Canales was more than 50% at fault, even today, he would have received nothing. So the jury actually considered that argument, Your Honor. But let me talk about what makes this case different from Sedenek and Dietz. And let me just start by talking about Dietz. Court knows Dietz very well. It was decided by this court, a much different panel, a completely different composition of the court. But what Dietz was about was it was a summary judgment case, number one. It wasn't a jury trial. And number two, the reason that the court's summary judgment was sustained in Karen Angelini's, Justice Angelini's opinion is because they approved the trial court striking the only expert testimony that the plaintiff produced by affidavit. So this is a no evidence summary judgment case based entirely on the fact that the court said, well, this is just the trial court was right and didn't abuse its discretion in excluding expert testimony. But what's more important, I think, is the Sedenek case. And because it's an old case, 50 years old, 51 years old at this point, you'll find that almost every court that cites Sedenek cites it for this proposition, cites it for the proposition that, as my learned friend acknowledged, it is often the case that the existence and report of prior injuries is probative of whether or not the defendant had knowledge. It's not usually cited for the proposition that prior reports indicate unreasonable danger, but it is sometimes cited for that as well. But Sedenek is also cited for the proposition, as the court has already pointed out, that is not necessary. It's not necessarily dispositive. I want to cite so what I did, Your Honors, was I went and looked at cases that cited Sedenek and explained how Sedenek was different or distinguished from an affirmed jury verdict. And the best one I found was Nevels versus HEB at 38 Southwest 3rd 294. 38 Southwest 3rd 294, a 2001 opinion from the Beaumont Court of Appeals. And I'm just going to quote from this Nevels case, quote, "We find the case to be distinguishable from the case at bar. In Sedenek, there was no evidence of an object over which one could easily trip that was placed in the aisle of a store in a location just behind where a customer would stand while picking up merchandise off a shelf. A shelf to which the store had endeavored to attract the customer's attention. In the case at bar, Nevels testified that she tripped over the cart as she turned away after picking up 2 cans of black-eyed peas from the shelf at the side of the aisle. A reasonable jury could determine from the evidence that the stock cart, or in this case, the pallet, was placed just behind where a customer would stand while picking a can off the shelf, and that such placement constituted an unreasonable risk of harm to a customer whose attention has been directed to the shelf and is not expecting such an obstacle." So let me just go through the record in this case and describe why our case is much more like Nevels than it is like Sedenek. Was there an object over which one could easily trip? Yes, we've already discussed that. Look at the record, volume 10A beginning at page 57, volume 11 beginning at page 222, volume 12 beginning at 194. Our experts and the other testimony and evidence in the case demonstrates that this object, the pallets, as I was saying before, only very recently, for economic reasons, by volume dealers, have been used as displays in produce. And the experts testified that when the industry began to do that, it created an unreasonable hazard. And one of the things they tried to do to address it was to develop pallet guards and also to put these warnings on the boxes. Did the store recognize the danger as it did in the Nevels case? Yes, they gave a warning. Second, look at the record volume 12 beginning at page 191, where our expert, Mr. Balian, testifies it's common knowledge that people can fall in this fashion and that it's also expensive, and that's why you need to use pallet guards to prevent it. There's the testimony that pallets were never designed for display. That again is in volume 11, page 206. And then you have the testimony of Pay and Save's own corporate representative, Mr. Griffith, who says that he knew of the danger of interacting with pallets and that people could trip in much the way that Justice Chapa has already described.
Mr. Chris, do you have a record site? Do you have a record site to the corporate rep testimony you just
Yes,
cited?
Your Honor.
Do you have a record site?
Yes, Your Honor. The corporate representative's testimony is in volume 13 of the record, and the useful portions of his testimony, I believe, or the most useful portions of his testimony, begin at page 234 and extend into the 250s.
Thank you.
That's where he testifies that he knew of the danger of interacting with pallets. He was on the board of the National Grocers Association for years. He was present at shows where pallet guards were marketed prior to this incident, and he admitted that he could foresee that something like this would occur. You've also got the defendant's own expert, Mr. Thibodeau, in volume 12 of the record, beginning at page 239, who admitted that he knows of pallet guards and assumes that they would prevent or ameliorate a trip hazard. And we've also got the testimony of Mr. Griffith that he had personally seen solid-edged plastic pallets that didn't need guards at H-E-B and Walmart, and this is again in volume 13. It begins at page 281 of the record. And that's why this case is so much more like Neville's versus H-E-B than it is like Sideneck or the other cases cited by the appellant. There's one other case that we cited, the Corbin case, which of course, Corbin versus Safeway Stores is the watershed case from the 1980s that we're all familiar with, where the court for the first time adopted the new second restatement with respect to the duty owed by premises owners. There's also the case of Farrar, and I don't believe this is in our brief, Farrar versus Sabine Management. This is at 362 Southwest 3rd, 694. Both Farrar and Corbin state very explicitly to move on from the question of unreasonable danger to the question of either constructive or actual knowledge. Both Corbin and this other case, Farrar, make clear it's always been the law in Texas. If the defendant creates the condition, that in and of itself is evidence that the defendant not constructively knew or should have known, but actually knew of the condition and its unreasonable danger. And on this record, it is undisputed that the defendant created this display. They simply are not allowed to challenge a jury verdict that says they had actual knowledge of this unreasonable danger under circumstances like this, where they created the display and they knew there was a danger, as evidenced by the very fact that there are warning labels on the display. In fact, what the defendant's defense in this case, it doesn't have a defense, but if I were defending or representing the appellant in this case, what I would say is, look, it's clear that there's an unreasonable danger here. There are warning signs on the pallet. It's clear that we had actual notice of this condition because we created it. And then what I would do is try to argue about whether or not they had taken sufficient steps to ameliorate the danger that's obvious to everyone. But they haven't done that. They haven't even briefed that point or brought it forward on appeal as something that was not supported by sufficient evidence. Because that's what we really have here. We have an entire industry outside, apparently, of South Texas. We have an entire industry that knows about this danger, has actual knowledge of it, and knows how to protect against it and prevent people like Mr. Canales falling, but simply did not do so.
Okay, but Mr. Chris, hang on one second. Mr. Chris, I have a question for you.
Yes, Your Honor.
So there's no question that there's lots of testimony in the record about the pallet guards and that the pallet guards exist. And there is some testimony that they are not commonly used in the area of Pay and Save, right?
Well, not the area of Pay and Save, Your Honor. Pay and Save has many stores outside of South Texas.
Okay, that's fair. But certainly the expert that testified said he went to several other stores in that area.
Yes.
And they use the pallets and don't use the pallet guards.
Yes.
So
There's
a
also
case that
testified
says,
that, go ahead, I'm sorry.
it's okay, go ahead, sir.
No, I was going to say he also testified, either he or the corporate representative testified, that while they didn't see pallet guards, they did see solid edged pallets at HEB. And that's in the record, and PanSafe keeps ignoring it. I'm sorry, go ahead, Your Honor.
That's okay. So, and I believe you're correct. I don't remember that specifically, but I know there was some testimony about HEB. So my question for you is that although there is evidence that these pallet guards exist, and I believe almost every expert testified to the existence of the pallet guards, CMH Holmes, that's a case, Southwest Third case, says, just because you knew of a safer, feasible alternative design without more is not evidence that the owner knew or should have known that a condition on its premises created an unreasonable risk of harm. So how do you address that? Just because there's a safer alternative is not sufficient evidence. 3 ways. First,
okay. Corbin versus Safeway Stores says you don't get to deny knowledge of the condition when you created it. The case that your Honor is citing is not a static condition case. It's not a case where the defendant created the condition. What those cases all talk about are transitory conditions where the defendant comes in and says, well, we didn't know the grape was on the floor because we only sweep every hour, and the grape fell in between the sweeps that we normally do. So that's point number one is, if you created the condition, you have actual knowledge of it. Not only should you have known, you do know. Number two, in this case, what's different about this case is, as I said before, we have an acknowledged unreasonable danger because of the warning. How can you say there's no danger of people tripping on pallets when there's a warning arrow that says, don't trip here?
Okay, but Mr. Chris, real quick to your point,
yes.
But the testimony, or at least my recollection of the record, it suggests that those arrows are for the corner of the pallets, the sharp corner of the pallet, not the area where the pallet ends and then there's that bottom, that space. So
that is correct.
So to suggest, so there's not, the arrows are not there for the Canales situation. They're actually there to warn of the corners and the sharp corners and tripping on those corners.
That's correct. That is correct, Your Honor. That is absolutely right. It is exactly the same as if we were in a trucking case and the trucking company put a warning sign on the dashboard that said, don't use your cell phone in your hand while you're driving. It's unreasonably dangerous. And the truck driver has a CB in his cab, and he pulls the microphone to the CB. He's got it in his hand, and he's talking on the microphone. Is the trucking company to be heard to say that they didn't know that was unreasonably dangerous? Of course they know it was unreasonably dangerous. It doesn't make any difference which hand he's got the cell phone in. It doesn't make any difference whether he's talking on a cell phone or on the microphone of the CB. They know about the danger. That's why I said before, what they're doing is they're trying to telescope in and artificially limit geographically and conceptually their duty in this case. They know about the danger of tripping on pallets. Their own corporate representative testified to that. They're not entitled to come in and say, well, we didn't know that you're going to trip on pallets on a Tuesday. We didn't know you're going to trip on pallets wearing cowboy boots. We just knew you were going to trip on pallets if you're wearing loafers. They're just not entitled to do that. The jury is entitled to draw the inference from the vast corpus of evidence that was produced in this case that they knew, not only they should have known, but that they knew of the danger. I see that my time is up.
Do we have 5 more minutes, or did they include the 5 minutes? I didn't notice that. I guess they included it.
No, Your Honor, I didn't include the 5 minutes.
Okay, please give him 5 more minutes.
So I've got 5 more minutes. I'll just say we've briefed the damage questions. We've briefed the gross negligence question. We briefed all of the questions that were raised in the case, and really the common theme that runs throughout the appellant's position in this case is they're not applying the standard of review. And as I was discussing with Justice Valenzuela, it's not a question of how this court might have decided the case as a juror. Maybe this court would have decided Mr. Canales was more than 50% negligent and we'd all go home. Maybe this court, as the jury, would have decided the punitive damage question differently. I don't know. But what I do know is that the standard of review is that we have to respect the jury's verdict in this case. And again, this was not a runaway verdict. This is a verdict that established 30% liability on Mr. Canales himself. And with respect to the damages in the case, really it all boils down to their argument that, well, those neck surgeries had nothing to do with this accident. Well, that's a fine jury argument, and they made it, and the jury rejected it. And as we detail in our brief, there was more than sufficient evidence for the jury to have done so and awarded the damages that they did. In fact, I want to point out the defendant themselves introduced into evidence exhibits, and specifically I'm talking about defendants exhibits 42 and 67, and you'll find these in volume 18 of the reporter's record, beginning at page 2240 and page 3706. These are the reports of Mr. Stanfill, who is a rehabilitation specialist, and Dr. Bramblett, who did a disability rating on Mr. Canales. And the evidence is that Mr. Canales was 44%, almost 50% disabled as a result of this accident and the injuries that he sustained. And under those circumstances, you just can't second guess the jury's verdict. As we cite in our brief in the case, the rule on pain and suffering, mental anguish, loss of capacity other than wage earning capacity, disfigurement, the rule on all these, as this court has said many times, is once there's sufficient evidence to establish the nature and severity of the injury, the Court of Appeals just can't second guess the discretion of the jury with respect to the amount to be awarded for those injuries, unless it is so great and essentially the behavior of the jury has some marker or something that indicates that it just shocks the conscience and the jury went off the rails. And we just don't have that here. What we have is essentially a compromise verdict. Yes, Your Honor.
What is your response to Mr. Frazier's argument regarding gross negligence?
My response to Mr. Frazier's argument regarding gross negligence is that based on Corbin and based on the evidence that I cataloged for Justice Chapa, I believe, all of the record sites, particularly the testimony of their own corporate representative, the jury had evidence from which they could infer under Corbin that because the defendant created the condition, the defendant had actual knowledge of the condition and its unreasonable danger, particularly under circumstances where they knew it was unreasonably dangerous and they knew that there was a substantial probability of harm, both because of their participation in national industry associations and because of their decision to use the warnings that every other grocer uses in acknowledgement of the trip hazard that's associated with the use of these pallets. And that's some evidence of gross negligence. There are many juries, I suspect, who may not have found gross negligence in this case. I think virtually every jury would have decided the liability portion of the case the way it did. I don't know what they would have done with the contrib portion. But I think there are plenty of juries, including this one, who would find this evidence sufficient to determine that the defendant was grossly negligent. Again, I think it really all boils down to the standard of review.
Justice has a question.
Mr. Chris, can you help me determine what the wording on the cardboard box says, if you have that information? Because all I can see is an arrow, and it's pointing down to the corner. There's another, triangular type design, but is there any verbiage on the cardboard box itself?
Let me find it. It's just, to me, what it is, Your Honor, I don't see any wording. What I see is a diagonally striped red and white arrow, and then and you'll notice there's a diagonally striped triangle. There's actually the warning arrow continues onto the cardboard triangle that I was describing that protects people from stepping into the slats on top of the pallet. I do not see any verbiage. I think above what you see there is NWD, something like that, in a circle. And then above that, between that circle and the picture of the watermelon slice, it just says watermelons.org.
Okay, thank you. I just didn't know if there was anything additional, because the arrow for me,
it's an insufficient warning. It doesn't warn or instruct anything.
And Justice Alvarez, may I ask one quick question to Mr. Chris?
You may, Justice.
Okay, thank you. Mr. Chris, with regard to the damages, there's a future disfigurement amount of 1.5 for future, as indicated, future disfigurement. My question for you is, my recollection is there's only testimony about the scar from the surgery. Tell me how to support the damages, the future damages for disfigurement, the 1.5, with where is the testimony I guess, in the record to support that there's anything other than the scar from the surgery?
I would point you, Your Honor, to the record sites I gave before, defendant exhibits 42 and 67, the disability evaluation, as well as the disability evaluation by the chiropractor and by the rehabilitation specialist. And I would also point you to the testimony of Dr. Siddiqui, which is in, I believe, volume 11 of the record site, that says he has a transverse scar as a result of the neck surgery. And recall, he's going to have a future surgery on a lower level of his spine that's going to produce another scar. And we have, and there's also evidence, not just of scarring, Your Honor, but it's very important to remember in connection with disfigurement. Mr. Canales has got an altered gait. He doesn't look right. He doesn't look the same as people who walk normally. I myself lately have developed a limp. It's kind of embarrassing. And the cases are such that they say you don't just need scarring, altered gait. He's also got the inability to manipulate his hand and fingers completely. He can't close his hand into a fist the way that he used to. These are matters of appearance as well as disability, and so they support the award. And we've given you a list of other cases that have supported multi six-figure or low seven-figure damage awards of this kind.
Thank you, Mr. Chris.
Thank you very much.
Mr. Chris, I apologize again for calling you Mr. Cross, probably because I went to Red Mass yesterday. So I am so sorry about that. But you may call me another name next time we see each other.
Most
Okay?
people call me Chris because they think it's my first name, and my question for them is, what do you think my last name is? I guess it's Cross. Thank you very much.
No, it's not. I'm sorry.
Thank you very much.
Mr. Frazier.
Yes, Your Honors. Thank you. If I may briefly touch on quick, hopefully, answers. First of all, there is evidence that Pay and Save uses this display, tab 3, in all of its stores that are in 5 different states. And there was evidence about beyond South Texas. The opinions that talk about the standard of practice, that the way it's done, the industry standard in South Texas, comes from Mr. Canales' own experts. We're just using their testimony. We have plenty of evidence that it's used outside of South Texas. Secondly, what's really critical here is in Dietz, as was discussed just as Alvarez in our colloquy at the beginning, this court struck the expert affidavit, as counsel, as my friend says, because, and I quote, the jury is just as competent as the expert to determine whether the sidewalk that had been there 18 years ahead dips from shoes and wet cement was unreasonably dangerous. And so that goes to the very point that this tab 3 is, you can look at it, it's not unreasonably dangerous. Now, what's really critical here, I keep hearing about, well, this is a static condition that Pay and Save put in, and so it therefore new. Well, the sidewalk in Dietz was put in by the owner. The rug that had loops that caught heels going to an object was put in by the premises owner. The hoses in Aguilar were put in by the university. So the fact that it was put in by the premises owner here doesn't change anything. And let's make it clear, as I think that it was addressed by Justice Chapa, the arrows are to avoid tripping on the exposed corner because of the octagonal side shape of the bin. And Mr. Canales made great pains to say, I didn't trip over anything. I didn't trip over that corner because going around, it sticks out. And that's what that's there for. No, I didn't even look at that arrow. It wasn't an issue. I put my foot inside the pallet. So the fact that there was this arrow is no evidence that we knew and tried to fix it. In the cases that we cite, there is the next case. Sorry, page 20 of our reply brief. Can't pronounce that today. That's the case where we addressed the convention center had several stairs, and the plaintiff fell down the stairs and said, it was dark. There was no lighting. I couldn't see the stairs. And look, the stairwells on the other side of the convention center, You put in lights, you put in more floodlights, and therefore you knew it was dangerous, and therefore this, because it had not been upgraded, and the court said that is not evidence that the stairwell was unreasonably dangerous. Your Honors, I don't know how we can get more clear in the case law. This case fits into Dietz, Seidnick, and all those cases that say, expert or no. In Brinson Ford, there was an expert, and they said that expert's opinion was just conclusory because you can look at the situation, you can look at the railing at the dealership, it's not unreasonably dangerous. So let's get that very clear, that this case fits in the other cases, and the fact that it was static doesn't change things. Now,
May I ask you a question,
yes.
Mr. Frazier? You said
Yes.
right now that the experts' testimony should not come in, at least their opinions. Are you saying that their entire testimony should not be considered by us, or maybe I misunderstood that?
Okay. Under the standard of review, and we are applying the standard of review set out well and full in the City of Keller case. That standard of review says that you cannot ignore evidence that contradicts facts or opinions on the dispositive issues. And if an expert's opinion or assumptions are contrary to the evidence, they are given no weight. So it's not so much that they shouldn't come in, it's just that the court should give it no probative weight, no probative value, because it's rendered without probative value by the standard of review in Keller and in other cases from this court. You can't ignore what the real facts are. And the real
And
facts
I agree
are,
with you. Yeah, I agree with you, Mr. Frazier. But what my question was, do you want us to totally not consider anything, or just those, I guess, those points of view, even if we don't need an expert, those points of view with respect to that comply with the evidence at hand?
well, two things. The opinions, for multiple reasons that we brief, are just not probative if you want to look at it. And secondly, as in Dietz, it doesn't help in the court deciding, which in Dietz, the court decided it's not unreasonably dangerous. So anyone can determine that. The jury looked at that and said that, common people can tell it's not unreasonably dangerous. So actually both, but their opinions on the key issues, and that is that the openings constitute an unreasonably dangerous condition. That key opinion, which goes to the first element that we've been talking to, and that's the case. That opinion, those opinions cannot be given probative value. They're not supported by the assumptions they make. They're not explained. The basis on which they're made either doesn't exist or doesn't support their opinions. And so the court under City of Keller has to look at the controverting evidence, look at all the evidence now, and show that those opinions simply are not probative, and therefore are no evidence to support the jury finding.
Well, there's no evidence to support. I mean, the picture's evidence. You would agree with me if we discard all, and that's the problem we're having. We discard all the expert testimony. We still have the picture, right? And the jury could decide whether it was, dangerous or not.
Well, the jury can decide that, and in the cases in which we have cited, the jury or the fact finder looked at the sidewalk, looked at the hoses, looked at the water, and the court, as a matter of law, said it's not unreasonably dangerous. And if this pallet, again, they're saying the opening is unreasonably dangerous. So if the opening, just by being an opening, is unreasonably dangerous, when in 14 years there have been no falls from the opening, there have been no injuries, been no complaints, and more importantly, if you want to go back and open the door to their expert's testimony, Your Honors, they could not explain that. One expert said, well, we just got lucky. Really? That's an expert opinion? Okay, well, that's not competent. We just got lucky. The thing is that there is simply no evidence that this is unreasonably dangerous, again, let's go back to the definition that this court used in the Supreme Court used.
Mr. Frazier, if I might interrupt you though, let's go back to the charge of the court and the manner in which it was submitted to the jury.
Yes.
And I'm reading verbatim. It says, with respect to the condition of the premises, Pay and Save was negligent if the condition posed a unreasonable risk of harm. So
right.
You're focused on unreasonably dangerous.
Well, I believe, Your Honors, that in the case law, that is synonymous. An unreasonable risk of harm, an unreasonable dangerous condition, still requires that from the reasonable person that looking at the condition, that there was a probability of a harmful event that you would have foreseen it, so that it posed an unreasonable risk of harm. And that requires, see, it goes on about just knowledge and then about care. But the case law that this court has to apply to the jury's finding is there evidence in this record that there was sufficient probability of a harmful event when there hadn't been one in 14 years, and the experts, the plaintiffs, witnesses could not point to any event remotely like this. They would say generally,
Mr. Frazier,
oh, yeah,
Mr. Frazier, respectfully, I'm not too much interested into lack of prior incidents or accidents, because I do take each case on its own merit. So let's just set aside that argument for a second, please.
Yeah.
I'd like to go back to the photograph. I'm still hung up on the arrow because I'm in fact confused as to what it should tell me as an ordinary person walking into the store, simply because of the fact that there does seem to be an opening at the corner. And it does seem that there is cardboard at the corner covering an open and obvious hole. So tell me how the jury cannot weigh that and see that for themselves and determine that this potentially could have posed an unreasonable, dangerous condition as to Mr. Canales.
Okay. Thank you, Your Honor. Great question. Here's the evidence in this record. The evidence supports or says that the purpose of these arrows is to show that there is an exposed corner, like a triangle, because of the design of the bin and the square of the pallet, and therefore
Yes,
not
sir.
to trip
Mr.
over
Frazier,
that corner.
I'm going to interrupt you right there. There is, and I agree with you, there is an exposed corner, but if you look underneath the piece of cardboard, there is also an open area. There's also an open space. I can see it in the corner pointing directly at me, and then the one off to the right. If you look closely, okay, so tell me why the jury couldn't determine for themselves in deliberations that too, Pay and Save did create this design, this condition. Why didn't it have flaps, cardboard flaps covering the sides of the pallet? Because it did cover the corners.
Well, Mr. Canales was adamant. The arrows played no part in his injury, and in the condition that he is claiming in this case was unreasonably dangerous. So that again goes to something else. He would say that has no part. In fact, he testified, I didn't look at the arrows. That had nothing to do with it. The evidence is they were there to prevent tripping. I didn't trip. It's the hole. So I would say, Your Honor, respectfully, that those arrows and whatever it's pointing to, whether it's the corner or whether there's something underneath the cardboard because it's open, it's not relevant to this case, because that's not the complaint of what's dangerous. It's the opening. That's it.
It's a great response, Mr. Frazier.
Thank you. We ask that the court grant the relief we requested and reverse this case. Thank you, Your Honor.
Mr. Frazier and Mr. Chris, I'm going to give you a story. I went to UT, and Professor Charles Allen Wright always used to call me Miss Alvarado, and I did not like that. So I am so embarrassed, Mr. Chris. I'm just so embarrassed. I don't know why I called you the way I called you. I've known you so many years. So, Mr. Frazier, Mr. Chris, this has been a very nice argument. You now understand why we needed oral argument. Thank you for your arguments. Your case has been submitted, and the court will issue an opinion and judgment as soon as practicable. If you wish a recording, make sure to contact Michael Cruz, the clerk of our court, and he will provide you with a recording. Thank you very much. We are adjourned.
Thank you for having arguments. Thank you for having argument. We appreciate it.
Very interesting case, and you made it very interesting. Thank you very much. This court is adjourned, and the Zoom call is terminated.